School desegregation orders will be lifted, according to Trump officials. Some parents assert that they are still required. Faraday, Louisiana. The differences are obvious even from a distance. Barbed wire surrounds the old and worn walls of Faraday High School. Vidalia High School is clean and bright just a few miles away, with a new library and a blue V painted on orange brick. 90% of Faraday High is black. Whiteness is 62% at Vidalia High. According to Brian Davis, a father in Faraday, the disparity between the schools suggests that we're not supposed to have the finer things for black families. He stated, "It's almost like our kids don't deserve it." The schools are in Concordia Parish, which was ordered to desegregate 60 years ago, and continues to operate under a court-ordered plan today. However, there is a growing push to free the district and dozens of others from decades-old orders that some people consider to be outdated. The Justice Department announced its intention to begin reversing court-ordered desegregation plans from the civil rights movement in a remarkable turn of events. Beginning in April, authorities lifted a 1960s order in Plaquemines Parish, Louisiana. Others will bite the dust, according to Harmeet Dillon, who is in charge of the department's Civil Rights Division. It comes as a result of Republican governor pressure. The state's remaining orders should all be lifted by Jeff Landry and his Attorney General. They characterize the orders as a burden on districts as well as relics of a bygone era when black students were still barred from attending some schools. The orders were always intended to be temporary. School districts can be released if they demonstrate that segregation has been completely eliminated. Despite the stark racial disparities that still exist in many districts, that objective remains elusive after decades. According to civil rights organizations, it is essential to maintain the orders as instruments for addressing the legacy of forced segregation, which includes differences in student discipline, academic programs, and teacher hiring. They cite Concordia as an example, where the decades-old order was used to stop a charter school from giving admission preference to white students. According to Dual Ross, the NAACP Legal Defense Fund's Deputy Director of Litigation, Concordia is one where it's old, but a lot is happening there. That holds true in many of these cases. They are not simply observing in silence. Integration debates are far from over. Before President Trump took office last year, Concordia Parish turned down a plan from the Justice Department that would have ended its case if the district combined several elementary and middle schools that had a majority of white students and a majority of black students. Residents of Vidalia strongly opposed the plan at a town hall meeting, claiming that it would disrupt the lives of students and expose their children to drugs and violence. The proposal was criticized by a representative from the Louisiana Attorney General's office, who stated that the Trump administration would probably rethink previous orders. Paul Nelson, a former Concordia superintendent, stated that the district would have received a death sentence if it had accepted the plan. According to Nelson, who seeks to have the court order overturned, white families would have sought refuge in private schools or other districts. After leaving the district in 2016, Nelson stated, "It's time to move on. Let's start building for the future, not what our grandparents may have gone through." Derek Davis, the athletic coach at Faraday High, was in favor of merging the Vidalia and Faraday schools. He stated that when his teams visit schools with more recent sports facilities, the disparities in the district become more apparent. He stated, "It seems to me that if we would all combine, we can all get what we need. If a school is merged solely for the purpose of achieving racial balance, some people oppose it." According to Faraday's school resource officer Marcus Martin, who is black like Derek Davis, restricting and going to different places they're not used to, it would be a culture shock to some people. The school board and the current superintendent of the district did not respond to inquiries for comment. Racism cases can use federal orders to their advantage. More than 120 districts in the South, including about a dozen in Louisiana, are still subject to desegregation orders from the 1960s and 1970s. Shahina Simons, who led the Justice Department section that oversees cases involving school desegregation up until April, stated that referring to the orders as historical relics is unequivocally false. She stated, "Segregation and inequality persist in our schools and districts still subject to desegregation orders. Families experiencing discrimination can directly contact the Justice Department or the court for assistance if court orders are in place." According to Simons, the only other option is a lawsuit, which many families cannot afford. The order contributed to the conflict over a charter school in Concordia that opened in 2013 on the site of an all-white private school. A judge ordered Delta Charter School to create a student body that was representative of the racial demographics of the district in order to safeguard the area's progress on racial integration. However, in its first year, only 15% of students were black. Delta was ordered to give black students priority after a court challenge. Approximately 40% of its students are black today. In recent times, desegregation orders have been used in other cases throughout the state. One resulted in a directive to address the disproportionately high rates of discipline experienced by black students, and another saw the relocation of a predominantly black elementary school from a location close to a chemical plant. Some desegregation orders could easily be lifted by the Justice Department. Because the Justice Department was solely litigating the Plaquemines case, the original plaintiffs were no longer involved, so the Trump administration was able to close the case without much opposition. Because Concordia and a number of other districts are in the same situation, they could be dismissed quickly. The case of Concordia goes back to 1965, when the area was strictly segregated and home to a violent Ku Klux Klan offshoot. The federal government stepped in when black families in Faraday filed a lawsuit for access to all white schools. White families left Faraday as the school district integrated. The demographics of the surrounding areas were reflected in the schools in the district. Vidalia is mostly white and receives tax revenue from a hydroelectric plant, whereas Faraday is mostly black and has low income. The high school in Monterey, the district's third town, is predominantly white. Ronnie Blackwell, a Vidalia resident, said at the December town hall that the neighborhood feels like a Mayberry, which is great. Blackwell was referring to the fictional southern town from the Andy Griffith Show. He stated, "Probably destroyed more communities and school systems than it ever helped by the federal government. Concordia must comply with the court's order by allowing students from predominantly black schools to transfer to predominantly white schools." Additionally, it compiles reports on student discipline and teacher demographics. According to court documents, Concordia is scheduled to argue that the judge should dismiss the order after failing to reach an agreement with the Justice Department. In the meantime, all but 2 of the attorneys assigned to the case by the Justice Department have resigned amid a flurry of resignations throughout the federal government. Brian Davis sees little hope for improvement if he is not under the supervision of the court. He stated, "A lot of parents here in Faraday are stuck here because they don't have the resources to move their children from A to B. You'll find schools like Faraday." The term Faraday is, in my opinion, fading into obscurity.